and welcome to the Law Office of Justin Rosas. This month's video legal tip is about Ballot Measure 11. Where did it come from? What does it do? What are the current criticisms of it? And where do I believe that Ballot Measure 11 is headed? To begin, let's talk a little bit about the history of Ballot Measure 11. A lot of people have heard that term but don't necessarily know what it means other than to know that it's very serious. Now, for those outside the state of Oregon, Ballot Measure 11 is a voters' referendum that was proposed in 1994. We in the state of Oregon allow citizens to propose legislation or propose laws. And if they get enough signatures and basically go through the appropriate process, those proposed laws can be put on the ballot along with things like the presidential election for you and I or the common person to decide whether or not this law should come into effect or not. And it's not a constitutional amendment. So where I grew up, the people can pass constitutional amendments, but there are not voting referendums. So Ballot Measure 11 was a voters referendum, and it was proposed by a group called Crime Victims United. And in the 80s and 90s, groups like Crime Victims United were really prominent. Those were groups that came along and they asked for stronger sentences based on the fact that they did not feel that they were getting justice based on the current sentencing structure. They felt like things needed to be more severe. As a matter of fact, there was a gentleman named Kevin Mannix who was really behind Ballot Measure 11, and Mr. Mannix did not believe that people could be reformed. He believed very deeply that any time you could keep a person who would commit a Measure 11 crime off the street was the best way to address that societal problem. So this group proposed and passed Ballot Measure 11 through a voting referendum. It was on the ballot and it was voted up. And the function of Ballot Measure 11 was to set mandatory minimum sentences for certain serious crimes within the state of Oregon. And mandatory minimum is another one of those terms that you may have heard but may not completely understand, even though it's somewhat apparent what it is. A mandatory minimum sentence strips the choice from a judge. It takes the discretion away from the judge, is the legal term, but strips the choice from the judge, the prosecutor, the jury, or the defense attorney as to what a sentence would be, and instead of requires that a judge put in a mandatory minimum sentence that's day for day that a person has to serve in prison. Now, mandatory minimum sentencing under Measure 11 starts at, I guess the shortest of those sentences is 5 years and 10 months, which comes out to 70 months, and it goes up to 300 months, which is 25 years. So, for instance, for murder, the mandatory minimum sentence under Ballot Measure 11 is 300 months or 25 years. And it comes down from there. And the other crimes that are in Ballot Measure 11 are all relatively serious: rape in the first degree, sexual abuse in the first degree, sexual abuse in the second degree, unlawful sexual penetration in the first and second degrees, robbery in the first and second degrees, assault in the first and second degrees, manslaughter in the first and second degrees. And as you can imagine, just for those that don't know, first degree is the worst degree, and coming back from there, it gets a little bit more relaxed. And so the sentences get lesser depending a little bit on what the crime is. So assault in the second degree and robbery in the second degree, for instance, are two that are towards the minimum, towards the 70-month or 5 year and 10-month requirement under Ballot Measure 11. Now, one thing that people ask is, well, what's the practical effect of a Measure 11 or of a ballot mandatory minimum? Why are people complaining about it? Well, I'd like to use an example from assault in the second degree. Now, assault in the second degree can be committed in 4 or 5 different ways under the statute that sets up what assault in the second degree is. One of those ways is committing basically an assault in the fourth degree, or committing a physical injury upon another person while you are using a weapon. Now, the problem with having assault in the second degree be a mandatory minimum crime is that those things can mean a wide variety of conduct. So, you or I might think of a weapon as a gun or a knife, but under the case law, things that could be weapons are the ground, a wall, a shoe, basically anything extra, anything beyond just your fists or your body becomes a weapon under the law. So, for instance, one way of committing an assault in the second degree might be someone who's 19 years old, who has, some mental health issues and is intoxicated, who's never really been arrested, never committed any sort of big time mistakes that can be pointed out by the state, ending up in a situation with someone where they hit them with their shoe and cause a black eye or maybe perhaps some bleeding just a little bit. And that could be an assault in the second degree that could submit somebody to a 5 year and 10-month sentence. And at the same time, if someone were attacked with a crowbar by a person who'd been arrested 72 times while they were non intoxicated and they had planned it for 3 months. So they had waited and cased the person's home and then finally figured out when they'd be there, and they went out and bought the tire tool, especially, or the crowbar, especially, for this attack, and then really brazenly attacked and beat someone. The mandatory minimum sentence is also 5 years and 10 months. And that's the kind of thing that judges used to be able to take into consideration. And it's not like prosecutors are completely blind to the differences between the first circumstance and the second circumstance. But Ballot Measure 11 does create a situation where both people are looking at the same thing if they proceed to trial. So let's say the less aggravated one has a valid defense, a good defense, perhaps self-defense or a diminished mental capacity, since I brought that up. That person is very unlikely to try their case, to go to trial, because of the fact that they are looking at a 5 year and 10-month sentence no matter what if they go through trial and lose, even if the jury wants to have sympathy on them. But they feel like they must fit the crime, fit the law directly to the facts, and so they find a person guilty, but they would otherwise sentence them lightly. They don't have that option. Of course, juries don't sentence, judges do, but the judge doesn't have that option. So it stripped the judge of the choice to sentence someone to less. And it stripped the judge of the choice to sentence to someone to less based on the fact that they didn't have much of a record, or based on the fact that the harm was less than typical, or based on the fact that there might be a treatment program that would be available that would help out more. And so Ballot Measure 11 came along and said no to that. The other thing Ballot Measure 11 came along and said no to was alternative incarceration programs. So if I have a client who gets sentenced to a prison sentence that's not a Measure 11 crime, they're eligible for AIP, or Alternative to Incarceration Programs. What that does is that gets you out of your cell while you're in prison. It doesn't get you out of your cell to go make ice cream sundaes or spend taxpayer money. It gets you out of your cell to go down the hallway and learn skills that might make it so that when you get out, you have hope, you have a plan, and you have a positive way of dealing with your difficulties. And so those types of alternative incarceration programs are things like boot camp, or a recognitive structuring program that the Oregon State Penitentiary has. There are also drug and alcohol programs and anger management programs. And so what those do is they allow someone to go through the program and gain valuable life skills for after they are released, since basically everyone does end up released, in order hopefully to give that person a position where they can move forward with life instead of just falling back into the same cycle. Ballot Measure 11 takes away the ability of a person to do alternative incarceration programs and instead just sits them in a cell while they're in prison. And then they're released without those life skills. And of course, I sort of have a hard time understanding how we believe that that's a better situation to reduce crime than the situation that we previously had. The other benefit it takes away is something called good or earned time. And good or earned time is a way that the prison board can reduce a person's sentence based on the fact that they did not commit assaults or otherwise act up in prison. And that's 20 to 30% off of their overall sentence. So if it's not a person-to-person crime, an assault or something like that, it's 30% off. Otherwise, it's 20% off. And someone that's sentenced on a Ballot Measure 11 does not get good or earned time. That also takes away, in some ways, an incentive to be good while in prison, and tends to make people more likely to be involved in assaults while in prison, given that there is no benefit. And of course, they're not being given classes or skills that would help them understand why that isn't a good decision, even if there is no benefit. So Ballot Measure 11 takes important things away from people who would otherwise be able to learn life skills that could help them after they get out of prison. And again, that's partially because the sponsor of the bill literally believes that there's no way to reform people who commit these types of offenses, just blanket believes that there's no way to reform those people, and thus has given up. Now, that is short-sighted, in my opinion, because it doesn't recognize the fact that people are going to get out anyway. And what we've noticed since the 80s and 90s, when groups like Crime Victims United were able to pass mandatory minimum sentencing laws, is that our prison population has ballooned. Our prison population has exploded. It's huge. It's the largest prison population in the history of the world, and we call ourselves the land of the free. It's not only the largest population in the history of the world, it's the largest per capita prison population in the history of the world. And those prison populations, that booming prison population, has not solved our crime problem. Quite the opposite, and it hasn't solved our addiction problem either. So many people believe that those bills were short-sighted, and they're currently going under a lot of criticism, both for not giving people skills once they get out of the system, for being inflexible as to the differences between one case and the other, and for forcing our prison population into a system where it is crushing our state budget. And I think we can all agree that we certainly would rather a dollar be spent on textbooks for school or for children's education or children's benefits than we would for in the incarceration of adults. Some people say, well, you're talking about treatment classes, doesn't that cost something? And it's been shown that by far the cost of treatment is cheaper than the cost of more prison, that treatment programs do work, and that in fact they do reduce someone's likelihood of committing another crime much greater than a prison sentence. So the idea that it's a big time deterrent to have these huge sentences is a farce statistically. One thing you have noticed over the last 10 years that I think is positive for this cause is that there are both conservative and liberal organizations who are behind this cause. So Right on Crime, they're a right-wing um, organization, very much engaged in sentencing reform and the reduction of Measure 11. They've been really engaged in the state of Texas in reforming the prison sentence system, down there. Um, there are also groups on the left, the Sentencing Project, and other Democratic groups have started to have movement on the same issue. So you're seeing some bipartisanship, which is shocking, really, on any issue in this day and age. And I do believe that it relates a lot of times to the budgetary concerns more so than the concerns over people's liberty. Regardless, that criticism has made its way to the Oregon State House, to the Oregon Senate and the Oregon House. And there was big time discussion this year about perhaps eliminating robbery in the second degree and assault in the second degree from ballot measure 11. But it's very rarely a popular position for a legislator to take, to go soft on crime or to go softer on crime, to be perceived as soft on crime. And while it's not soft on crime to suggest that our society should spend its money in the most appropriate way to make society safe, it's perceived as soft on crime to reduce a sentence for any crime. So while that conversation happened this year, it actually did die, and there's some reason to be skeptical of whether it will change in the immediate future because of the fact that individual legislators don't want to be seen as soft on crime. If it's an issue that you're engaged and involved in or that you care about, I do think talking to your state legislator and letting them know that you don't think there would be great blowback, letting them know that there would not be blowback from you, even maybe if you voted for ballot measure 11 initially, is one way to hopefully see something change on the ballot measure 11 front. Now, I do believe ballot measure 11 will eventually have to change because the state budget is going to progressively get worse and worse until some of those issues are resolved. Now, I don't believe it will be changed and completely eliminated. I just don't see that happening. But I do believe that ballot measure 11 will be reduced and can be altered in a variety of ways. There are currently a couple of escape valves within ballot measure 11 that sound exactly are exactly like what they sound. An escape valve is if certain circumstances are met, you can get outside of ballot measure 11 on a few of the crimes. And I think creating more escape valves is going to be the initial way in which ballot measure 11 is changed. Knowing all this, Measure 11 is incredibly serious. So if you're watching this video and you or a loved one or someone you know is either being investigated for or has been charged with a ballot Measure 11 crime, you absolutely have to get in to see an attorney. It's not going to just go away. You cannot just talk yourself out of a ballot Measure 11 investigation. The police are very likely to refer that case to the district attorney's office, and going it alone in that situation is really a ridiculous decision given what you're looking at. So if you are charged with a ballot measure 11, get in to see an attorney. And if you're concerned about ballot measure 11 and the effect that it has on our society and the prison population, it's important that you get in with one of those groups, Right on Crime, the Sentencing Project, whatever your political affiliation is. Speak with your local state senator and try to push this issue into the forefront as we move forward. I want to thank you so much for being here this month. We'll be back next month with a lesson about felony sentencing guidelines grid. And then in October, we'll talk a little bit about drug cases and some of the common myths relating to drug cases. Thanks again.